Hello, everyone, and welcome to today's Catalyze webinar. My name is Marissa Eastman, and I lead outreach for the Catalyze program on behalf of the Catalyze Coordinating Center from RTI International. With me today representing the program are Mike Peck and Nitin Agarwal from NHLBI. I am so excited to kick off today's topic and introduce our speaker. Intellectual property, as we know, is a crucial topic for our Catalyze investigators, as well as anyone else developing or hoping to develop a commercializable product. And here today to guide us through patenting and patent protection for biomedical innovations, I'm very happy to welcome John Xu, who is an entrepreneur in residence at BioHealth Innovation, also entrepreneur in residence for NHLBI and longtime supporter of the Catalyze program. Dr. Xu is an expert in evaluating intellectual property matters and IP litigation. So, John, without further ado.
Great, thank you. Let me just give a quick background. I have a Ph.D. in chemistry. I switched over to the law very quickly after that. Was in private practice for 24 years. I started in patent prosecution, quickly switched over to patent litigation, did that for the bulk majority of my career, and focused on pharma litigation. So moving on to the slides, just a quick notice that this is not legal advice and not for legal advice purposes, and you should consult your attorney for any legal advice that you seek. So broadly speaking, there's 4 categories of IP: patents, trade secrets, trademarks, and copyrights. This is focused on patents and goes through patent prosecution, then a little bit about the post-grant proceedings at the USPTO, then patent litigation, and then how it plays out in pharmaceutical patents. So to start off, patents, there are 2 distinct areas, patent prosecution and patent litigation. Patent prosecution is a process of getting patent out of the USPTO. You deal with the USPTO and the patent examiner. Patent litigation is you're asserting or defending against a patent, and you're dealing with the federal courts and federal judges. Prosecution can be conducted by the inventor, that's called pro se, or a patent attorney or patent agent. At the USPTO, patent attorneys and patent agents are viewed as the same. To be a patent attorney or agent, you have to pass a patent bar. It's a specific test. You have to have a degree in science. And once you pass it, you get a register number, and you can look up the register numbers on the USPTO website, at that website there. Patent litigation, you're asserting or defending against a patent. It's only federal courts. It's completely federal law. There's no state law patent. You appeal to the federal circuit and then to the Supreme Court, although the Supreme Court doesn't have to hear your appeal. Litigation teams usually have a mix of between non-PTO attorneys and PTO attorneys. So for patent prosecution, it starts at the United States Patent Office. It's in Alexandria, Virginia. Most examiners aren't there, though. They have a hoteling program since 2007. And patent prosecution procedures, if you want to know anything about the patent prosecution procedures, you can look it up in the MPEP, the Manual of Patent Examining Procedure. It was considered, it's called the Bible of patent prosecution. Everybody used to have a copy of it. It's a big, huge telephone-sized book. Now it's all electronic, and you can access any of it on the website at the USPTO website there. So for US, there's 3 types of patents you can prosecute. There's utility patents, design patents, and plant patents. Utility patents is the vast majority of them. The statute uses the terms machine, manufacture, composition of matter, process. Basically, it's a thing or a method to make a thing or method to use a thing. Design patents are the ornamental look or feel of the design of the product. Not a lot of NIH grantees will get a design patent, but some will. It depends. If you have a medical device, for example, you might get a design patent. Plant patents are sort of a niche area. I doubt any NIH grantees will get a plant patent. I never dealt with them other than for the learning for the patent bar, and it's a specialized area, and I did not run it across any of these actually in my practice. So to get a US patent, you get the ball rolling by filing a patent application. You can file a provisional application or a non-provisional application. Provisional applications are not reviewed, they're not published, they're basically just a placeholder to get an earlier filing date. The importance is that you do get a filing date. So the filing date is a priority date, and it's to protect you from someone else filing patent application on your that covers the same invention you have, and it protects against publications later after your priority date. They can't be used against your application. That's why you do it. Provisional applications do not need to have a claim. Most of them do. It's usually good practice to write your provisional application like your non-provisional application, because it's going to need to be converted into a non-provisional application before a year comes up. If you don't convert it, then you lose that priority date. An advantage of a provisional application is it doesn't start the patent term clock. So it's the patent term clock is 20 years from your earliest filing date, but that's not the earliest provisional. That's the earliest non-provisional filing date. So it's an advantage there also. So once that year comes up, you have to file a non-provisional application. So it has to get converted into a non-provisional application to keep that priority date. You can either file a U.S. non-provisional application or you can file a PCT application. The U.S. non-provisional application, it'll get assigned to the examiner for examination, gets published, and the application numbers you typically see is inside the teens. If you file a PCT application, that's basically to keep your options open for PCT countries. There's more than 150 countries in the PCT. You file it in any of the PCT country offices, because NIH and innovators are in the US, they almost always file in the US. You can tell it has a PCT number in front of it. It also gets published. And then you have to enter the national phase. So there's a period where you have to enter the national phase, and that's when you pick which countries, the PCT countries you want. And that's a cost-benefit analysis, whether it's worth it to go into a particular country or area, such as the EPO. And again, that's a cost-benefit analysis, because as you enter more countries, it's just going to cost more money. So what happens with your application? So there's 3 requirements for a non-provisional application in the US. It has to be in English and has to have at least 1 claim. It has to have the oath or declaration from every inventor, and you have to pay your fees. The fees change on occasion. They actually just changed recently. You can see all the fees on the USPTO website at that web address down below. And there are some examples of some fees that are current for an application. In the big scheme of things, during commercialization, the fees are not the expensive part because pharma products are supposed to, pay off pretty big. Now, that being said, startups do not have a lot of money, I understand. So it can be look prohibitive. However, again, in the big scheme of commercialization, usually the fees at the patent office are not the highest issue for costs. So every patent application, non-provisional patent application, has to have at least 1 claim. Most have more than 1 claim, but it has to at least 1. The claims are very important because it defines the property right. It defines the mets and bounds of the property. They can be independent or dependent. If there's 1, it has to be independent, but if there's more, it can be dependent. So the Venn diagram here is the typical way independent and dependent claims are found, are shown. That the dependent claim has everything that the independent claim has, but it narrows down some aspect of it. So it's within the independent claim, but something about it is narrower than the independent claim. So here is an example of an independent claim and a dependent claim. The independent claim is a drug delivery system, has a transition term, comprising. There are 3 transition terms. There's comprising, consisting of, and consisting essentially of. Those are the different ones. They have different legal meanings. You see comprising mostly because it's open-ended. It allows the parts, the limitations that are in the claim, but it also allows additional ones too. So you see there are elements afterwards: a unit, an aerosol delivery port, a flow passage, 3-dimensional rod array. The dependent claim too incorporates everything from the independent claim, but then it narrows down something. In this case, it's narrowing down the aspect of the successive rows. It's got to be a specific type of successive row. So what happens? You complete a non-provisional application, it receives a filing receipt. It then goes to an examiner in a particular art group that's relevant to your technology. And then the examiner will examine it. Usually it's about 2 years before you hear back a substantive review. It depends how backlogged they are. They're actually pretty good right now, as I understand it. But certain things can happen during prosecution. The applicant can submit prior art. It's in an IDS, an information disclosure statement. There can be a restriction requirement, means the examiner wants you to break up the claims and stick some claims into a divisional application. Still gets the same priority date. It's just he or she wants it broken up. The examiner can then send you an office action. That's typically what happens substantively. So the office actions, the first one's going to be non-final. The subsequent one, if it's the same reasons as the first one, it's going to be a final. If there's new reasons, then it'll be a non-final. So the applicant will then respond to it. They can do claim amendments. They can maybe submit a declaration. They submit arguments. The examiner, you can have an examiner interview. If you're still going back and forth and it's not resolved, you can file an RCE, a request for continued examination. That's to continue the prosecution, but you have a final on it, but you think that there can be still some movement going on. If there's not going to be any movement or the examiner sticking, you can appeal to the PTAB, the Patent Trial and Appeals Board. Ultimately, if the examiner agrees, they're going to issue some claims, you get a notice of allowance. So what are the kind of rejections that the examiner can give? First one is 101. Is it patent eligible? So there are some inventions that are not eligible. Classic examples are products of nature, mathematical equations, and abstract ideas. Traditionally, it's been a low bar. It hasn't been very hard to get over that. Most biotech inventions are going to be patentable. It's a thing. It's a chemical compound. It's a device. Those typically make it and easily. There are certain areas that 101 gets raised. Health apps, anything tied to computer, that typically will raise 101 issues. Biodiagnostics, just straight up diagnostics, that'll raise a 101 issue. If it's a natural product like DNA without any alteration, that'll raise a 101 issue. So typically that's 101s don't get raised unless it's in a particular area. 102, 103s, those are very common. Examiners almost always issue 102, 103s. 102 is anticipation. It means there's a piece of prior art that covers your invention, your claimed invention. That's what the examiner's saying. 103, it's not a single piece of prior art, but if you take one piece of prior art and you combine it with another or multiple other ones, the examiner's saying it's obvious in view of that. It's obvious to one of ordinary skill in the art, to the invention. The Graham factor is a famous case, Graham v. John Deere, and it sets out the obviousness factors that the examiner applies. Again, 102, 103s are very common, and a lot of times the examiner will issue a 102 on the independent claim and then issue a 103 on the dependent claim because the narrower issue, the narrower element may not be in the single piece of prior art, but they'll grab another piece of prior art and say, well, if you combine the two, it would have been obvious. Another rejection that is often given is a 112. There's three parts to 112: indefiniteness, lack of enablement, lack of written description. Indefiniteness is pretty common. You get over that. Usually the examiner is asking you to tweak the language, the claim language. That's usually what an indefiniteness 112 rejection is. Lack of enablement, lack of written description. You don't see those as much, but you do get them. Usually you point out where you say the examiner is missing it in your specification, or you might submit a declaration or an argument, at least argue that there's something the examiner is missing. And again, those are things that can be overcome, with the back and forth with the examiner. So what happens if the examiner sticks? You can appeal to the PTAB, the Patent Trial and Appeal Board. It's a process. You file a notice of appeal, you file appeals briefs, the examiner's answer, and there could be an oral hearing if requested. So the Patent Office keeps statistics on these. You can look it up on the Patent Office website. After the last fiscal year to now, to April, 64% affirmed, 8 affirmed in part, and 26 reversed. So you got about a 35%, and that's been fairly consistent at those statistics throughout the years. So, 35% chance of a partial win. Of course, case by case differences. Your case may be different than the actual statistics, obviously. So what happens? You get through the whole process, and success, you get a patent. Patent is issued, notice of allowance. You get some whatever claims the examiner agrees that can issue. You need to pay maintenance fees. The maintenance fees, again, change. They're on the USPTO's website for the schedule amount. It's 3.5 years, 7.5 years, and 11.5 years. And as they go up as time goes by. When will it expire? As I mentioned, it's 20 years from the earliest U.S. filing date. So it's a non-provisional date or a PCT date. You can have a patent term adjustment if there's delays at the Patent Office. Lately, the Patent Office has gotten rid of their backlog. At least a few years ago, I'd say like 10 years ago, 5 years ago, they had a backlog. It's been taking, as I understand it, it's much better now. But if there is delays on the Patent Office, you may be able to get time back. There are things called terminal disclaimers. Terminal disclaimers will cut your time. Why would you do that? It's you get an obviousness double patenting rejection. Basically, it's a commonly owned patent and application or two applications. The examiner saying they're obvious variations of each other. If you let them expire at the same time, the shorter the time, you could get the examiner may let the claims go, and usually that will overcome an over obviousness double patenting. You also, for pharma patents, you can get a 5-year extension from FDA approval process. It applies only to the first permitted commercial marketing. So it doesn't apply to every drug, but it applies to the first commercial marketing of that drug. So you got your patent, you go to the courts to enforce it, or you have to defend against it in the courts. Well, outside of the courts, there is a process now that companies can attack a patent at the USPTO. They're called post-grant proceedings. It came about by the AIA, the American Invents Act. It was passed in 2011. American Invents Act did two main things, two big changes. One, it changed the U.S. system from a first to invent to a first to file system. It used to be a first to invent. If you could prove that you were invented it earlier, you could go and argue at the patent office that you should get a patent. But now we're a first to file system. We want to be more consistent with the rest of the world. So now if someone beats you the patent office, of course, there are caveats to that, but you're going to lose against someone who files before you. The second big change was it set up this post-grant review. So it set up post-grant review and inter parties review challenges. The challenges at the PTAB, so you can file a petition with the PTAB, and then the PTAB will decide whether to hear your petition. They grant it, then they'll go through some briefing, and then you have a hearing, and then they'll decide whether the patent claims will be invalidated or be canceled, basically, by the patent office. It's less involved and less costly than a district court litigation, so that's why some companies feel that's a good option. However, pharma patents are challenged in this form less. They have, again, statistics at the USPTO. You can look them up. Last fiscal year, they had 1,200 petitions. And you can see the breakdown of the petitions. And pharma and bio is only 6%. This main area, especially IPRs, are basically more for the business method type patents, the ones that patent trolls, or they're also called non-practicing entities. They're the ones that they have. And it's sort of a cheaper way to try to fight those type of patents. Biopharma patents, by and large, they don't get as much traction with the PTAB and under IPRs. However, if you look at the petitions instituted, of those, it's 73%. So for the most part, companies make sort of a strategic decision. They typically don't go to this forum for pharma patents. However, if they feel they have a good shot, they feel they have a good piece of prior art, then they usually save those ones and they will file a petition, and then it gets instituted a fair amount of times. So not used very often, but when it is used, it's because you think you have a good shot. So if you're not in the IPR in the PTO, then you're in district court litigation. So district court litigation, it's defending or enforcing, it's enforcing your patent, or if you're on the other side, it's defending against it. So patentees typically are the plaintiffs, and they're suing defendants, the alleged infringers. That's not always, it can be switched, but this is typically the way it works. Patent law, as I said, is solely federal law. You're not in state courts, you're in federal court. So it's federal subject matter jurisdiction, and it's at the United States District Court. The picture there is actually Delaware District Court. It gets appealed to the United States Court of Appeals for the Federal Circuit. It's a specific court to hear patent cases, appeals court, and then it can get appealed to the Supreme Court, but the Supreme Court doesn't have to hear it. You have to go through writ of certiorari, and oftentimes they choose not to hear patent cases. They're much happier if the Federal Circuit deals with it. So they typically don't hear it. Also, it's not a typical Supreme Court case because there's not a split in the circuits. There's not a situation where the First Circuit says one way and the Second Circuit says a different way. Federal Circuit is the only circuit that handles patent appeals. So there's no split in the circuits. And it's also doesn't really split along ideological lines that much. This is one of the few areas in the Supreme Court where you see 9-0 decisions much more than you would in other areas. And the big seminal cases, a lot of times it's 9-0 or 8-1. That's not unusual. Even I had two cases that went up to the Supreme Court, both of them were 9-0. It's not that unusual at the Supreme Court for patents. So what happens at the district court? So you need to have a district court with jurisdiction over the alleged infringer. And for small molecule Hatch-Waxman cases, I'll talk about a little later, vast majority, over 90%, get filed in Delaware and New Jersey. That's where the pharma companies live, are incorporated, or exist as a principal place of business. So this is a general timeline for a district court litigation. It's a typical litigation. It's these parts are all in pretty much every federal district court case, except for claim construction, Markman hearings. That's unique to patent litigation. So it goes through a complaint, an answer. You get a Rule 16 scheduling conference with the court. They'll set up a schedule, go through fact discovery, depositions, and interrogatories, exchange of documents. Then you go through expert discovery, where the experts will submit expert reports, and then they'll be deposed. You have a pretrial conference where the judge will set your schedule for the trial, set the rules for the trial, set what evidence is going to be available for the trial. Then you have a trial, and then you can appeal after that to the Federal Circuit. Again, unique to patent cases, there's Markman hearing. Markman hearings are there's an issue about claim construction. So the claims have terms, and not surprisingly, litigation, the parties don't agree on what those terms mean. The term is to mean what a person of ordinary skill in the art would understand the term to be at the time of filing the patent application. When they don't agree, you brief it, and then you have a hearing, and then the judge decides what the term is going to mean for the case. It can be done at any time. There's no rule about when a Markman hearing has to be done, but all the parties want, and the judge usually understands, that it's better to have it before expert discovery, because if you have to argue the term an alternative means it could mean X or it could mean Y, it makes things very messy for expert discovery. So most cases will have it before expert discovery and have an opinion, a Markman opinion before expert discovery. Hatch-Waxman litigation, again, I'll talk about that a little bit. That typically takes about 2 years to go to trial. There's a reason for that I'll explain. There's a 30-month stay that's involved. That's why it's 2 years usually. Give you an example of a rocket docket. There are certain courts that are very quick. Eastern District of Virginia is very quick. It's a rocket docket. You are to trial 4 to 6 months after you file the complaint, and it will not budge. They go quickly. They do not care about your schedule, and you will be going to trial from 4 to 6 months. Federal Circuit appeals, typically they're about 1.2 years or so. That's the statistics these days, from notice of appeal to decision. So even if you get a trial decision, you're still going to have to wait about a year before you get a resolution of the case. And you can still appeal it to the Supreme Court. But like I said, the Supreme Court typically doesn't hear these cases. So moving on to the Hatch-Waxman, I referred to Hatch-Waxman for a little bit. So how do these play out in the pharmaceutical world? For small molecule drugs, that's covered under the statute Hatch-Waxman. So a new drug applicant, so there's a new drug application a brand will file to get approval to market a new drug. The ANDA, abbreviated new drug application, is the generic. So they will file an ANDA. What happens when the NDA is going through its process, the brand will list patents that cover its drug in the Orange Book, OB. And so it can be the API, it can be the drug product, it can be approved method of use. You can look up these OB patents on the FDA website. They're all available. When a generic files an ANDA, they will have to certify to every one of the patents listed in the Orange Book. And what they will do, if you do a paragraph 4 certification, the generic is saying that the Orange Book is invalid or not infringed. That causes a little system where the generic then sends a notice letter to the patent owner and the NDA holder, and then the brand needs to sue within 45 days of the receipt of the notice letter, and that will make an automatic 30-month stay by the FDA for the approval of the generic. And that's why trials usually happen about 2 years, because all the judges who deal with this Hatch-Waxman area knows about the 30-month stay, and it gives them 2 years to have the trial and then 6 months to get their opinion out, essentially. So that's why the timeline is pretty well known in the Hatch-Waxman litigation. Now, if you win, get a judgment that wins before the 30-month stay, then the FDA can approve. It's not something that, as we can see further, that doesn't happen a whole lot. One reason, and this is as we move forward, that Orange Book patents, as you might imagine now, the way the system works, is it's leverage for the brands. So the number of OB patents and the further the last expiring OBP patent is, you're getting more leverage. You're pushing that timeline now, essentially. So you have to have a non-expired OB patent to trigger the 30-month stay. So because you need a paragraph 4 P4 certification on at least one OB patent. But the more you have, the more it's going to raise costs, because now the generic is fighting on multiple fronts, multiple grounds, and usually the patent sets are different. They have different issues and strategy for them, so you're increasing the costs as far as the generic has to fight. And the generic needs to win on all asserted claims. So if you have 10 OB patents and you're asserting 50 claims, well, you got to win on all 50 claims. So that's going to raise issues and raise costs for the generic. Also, most cases settle. So the settlement negotiations usually happen when the litigation is going on. And the settlement date is going to be somewhere in view of what the OP expiry dates are. So if you pushed out the OB expiry dates to 10 years, well, the brand's going to be arguing from the 10-year date backwards. So that will, again, give more leverage for negotiations for the brand. Now, as far as OB patents go, the API patent, the patent that covers the active pharmaceutical ingredient, chemical compound, that is going to be the strongest patent. There's no non-infringement position because the generic has to have the API. They can't not have it. And they're typically difficult to invalidate. Brand has a lot of arguments to use to support it, and the generics arguments typically don't get a lot of traction in that situation. So for the most part, very, very typically, generally, these are strong patents. However, they're usually the first to expire, because when you develop a drug, you patent the the API patent first. That's what you first develop. And the later expiring patents that a brand can get can then extend the timeline, because the API patent's going to be the first one in the OB list to expire. Now, the other patents, they can vary in strength. It's case by case situation. It's factually specific. But if you think about it, so let's say you have an approval formulation, another OB patent. It's a formulation patent. It has the API, and then it has 1 to 10% mannitol, 2 to 5% stearate, whatever, different percentage of excipients. If the generic can formulate a non-infringing formulation that has 15% mannitol, for example, then that's a non-infringement position. That will be pretty good. Non-infringement's stronger defense than invalidity for them, usually, most times. The burden's on the plaintiff to prove infringement. The burden's on the generic, the defendant, to prove invalidity. So you've already shifted the burden onto the brand for non-infringement. Non-infringements also seem to get a little more traction with the court. So if you can get out of the claim range, for example, you have a non-infringement position, you've gotten a stronger position. The patent's maybe a little weaker. However, let's say your amount of mannitol is 10.5 and the claim is 10%. Well, you're a lot closer now. There's something called the doctrine of equivalence. The brand can then argue it really does infringe, and so that non-infringement position got a lot weaker. It may go away, and the patent got stronger. Same thing with approved indications. There's something called a Section 8 carve-out. If you can carve out that approved indication in your label from the generic, you have a non-infringement position. You look pretty strong. If the FDA doesn't allow you to carve that out, then that non-infringement position goes away. Patent got stronger. Same thing with the polymorph. If the patent covers an alpha polymorph and the generic has a beta polymorph, well, that's a non-infringement position. However, if the facts show that the beta polymorph converts to an alpha polymorph, okay, well, that non-infringement position might go away, and patent definitely got stronger. So again, it's case by case situation. It's fact specific. But as you can tell, litigation gets messy. Costs can rise as the messier it gets. And again, that's typically parties settle because both can find a win. Taking away the uncertainty of litigation is a win in itself, by itself. So that's basically the Orange Book Hatch-Waxman on a 30,000-foot level. If you go to biologics and biosimilars, they're covered under a different statute. It's called the BPCIA, Biologics Price Competition Innovation Act. It's part of Obamacare. It was passed. It was to find an abbreviated approval pathway for biosimilars in a similar way that Hatch-Waxman helped generic come to the market, or had an easier pathway for generics. They have an ABLA, an abbreviated biologics license application, or a 351K application. That's going to be the generic, the biosimilar. And then the reference product sponsor, that's the brand, that's the biologic. There is something called the Purple Book. It does not work like the Orange Book, though. You do not list patent. The brand does not list patents in the Purple Book. What happens is it talks about the biologic information. It has whether there's any biosimilar or interchangeable products that's been approved, and it has exclusivity periods for the reference product. Now, there can be patent information, but only if it's been disclosed to the ABLA filer through this patent dance. I'll talk about patent dance next. But as with the Orange Book, you can look the Purple Book up on the FDA's website. It's there, and again, they're public information. So what's this patent dance? Patent dance, the one thing to keep in mind is patent dance is not mandatory. You do not, the ABLA does not have to participate in it. However, if it does participate in it, the ABLA applicant and the RPS exchange patent information. It goes through the series of exchanges where they're talking about what patents should be asserted in a case, and then you have a negotiation period back and forth. And the BPCIA envisions basically a first wave and a second wave of litigation. The entire dance can take up to 245 days. And it's a little bit on the complicated side. So if I show another Let me see if I can show another slide here. Here we go. No. Well, bear with me 1 second here. Might be able to get it. Here we go. Let me see if I can share it again. Yes, there we go. Okay, so hopefully you see that now. This is from a website of one of the law firms that they put this up, this little convenient, handy dandy patent dance flow chart. So as you can see, it gets a little on the complicated side, but there's a period where the ABLA will then offer their application to the reference product sponsor. And then within certain timelines, they will provide each other lists. And then the list will go through in a negotiation, and they either agree or disagree on the list, but then that triggers what kind of litigation can be brought with whatever patents that are from the list. And again, this whole process can take up to 245 days. It's in the brand's interest, by the Biologics' interest, to slow the process down, so they will take as long as they can take. And it envisions first and second wave litigations. And if someone doesn't participate in it, there's also declaratory judgment actions. Again, this is the kind of trigger a situation when the participants do not feel like doing a little patent dance. So again, it gets on a complicated side, but that is the statutory structure that we have come up with to deal with patents in the biosimilar biologics world. And with that, I'm happy to take any questions you might have. And I think there might be in the chat, I'm not sure.
Yeah, great. Thank you so much, John. One question from the chat is, can you define terms, those used in claims, to make clear what is being claimed?
Right. So the the legal black letter law is that a patentee can be their own lexicographer, which means that if you define a term in your claim, in your specification is the written part of your patent, the description and the background and everything inside before your claims. You can define a certain term however you wish to define it. Now, you have to be clear about it, because without any guidance from the patent, the term will be, well, the term always is given what a person of ordinary skill in the art would have thought the term meant at the filing of the patent. However, if you clearly define it, then the evaluation will be, well, they clearly defined it in a particular way, and so that's how it is, and the person of ordinary skill in the art would have seen that they particularly defined it. So yes, in that sense, you can do that. And the specification does have specific descriptions of certain terms, and that does happen. However, most of the time, it's just based on the scientific knowledge. And so the terms have a common meaning when it comes to science. And that's typically what happens for most terms in patent claims.
Great, thank you. Another question from the chat. Could you talk about the strategy around timing of patent filing?
So timing wise, again, there's two things that are always in the back of the mind of a patent attorney or an inventor. Is it's a first to file system. That's one. So if someone beats the patent office, that would not be good. And the second is prior art. So again, you get the priority date because you want to try to cut off prior art. If you make a disclosure, and again, there are certain rules within the statute. So all disclosures that an inventor makes will not necessarily be prior art, or not necessarily be counted against you. But for the most part, usually if you make a disclosure, it's 1 year after you've made that disclosure, that's prior art that's going to be used against you. So there's a timing issue there too. Now, let's take an example of a large pharmaceutical from the AbbVies of the world and the Mercks of the world or whatever. They keep things within their company pretty secret, so they usually have a good control over what's being disclosed and what's not being disclosed. And two, they usually have a good idea of what's out there also. So they have a pretty good idea about if anyone's working on the things they're working on and whether someone might beat them. So they usually have a better ability to time it, because the flip side is the longer you wait, the longer your date's going to be for expiry, because it's the earliest your earliest U.S. filing date, 20 years from your earliest filing date. So the advantage is to hold off because you get a longer date. The disadvantage is somebody might beat you, or prior art might come about that might hurt you. So that's a strategy you have to work, and that's up to your ability to know where you are also, because as you're developing, you might be able to claim more. So those are all different factors that go into it. But generally speaking, getting something on file is going to protect you, and so most people will err on the side of getting something on file. But again, that's a strategy issue. That's something you talk about with your counsel, and that's not sometimes an easy call, sometimes not an easy call. Hard to say.
Thank you. Okay. US patents only protect US activity. Can you apply to a foreign entity later?
Correct. U.S. patents only are within their borders, although they stop importation issue. There's importation issues they can stop. You can file in the ITC, for example, the International Trade Commission, and they can stop infringing goods from entering the country if you win. That's what you get. You get an exclusion order. But setting that aside, yeah, that's why people go through the PCT process. It's because if you do a PCT, say you file it doesn't, you can file, like I said, you can file in any PCT country. So if you file, you can file in the US. And then there's a period where you enter the national stage. And so you make a decision which countries you'll go in, but you get that priority date. So that's tied to your PCT filing. So that's typically what someone will do, because that will protect you in the PCT countries going forward. If you don't file in the PCT, if you don't file a PCT application, you simply file a US application. One issue that could arise, and again, it's always fact specific, but one issue is that once it gets published, a US patent application, it's public, it's basically prior art at that point against anything afterwards. And the international is not like the US in the sense that there's kind of a 1-year grace period in the US. Again, that's specific to 102. Most international countries don't have that. So that publication is going to basically hurt you, because that international will then look at that publication as a public piece of prior art. It doesn't matter whether you invent it; it's a publication that's published in the in the U.S. and the world. Basically, it's known. So that is another issue when it comes to international filing. That's why most times, if the people want international protection, they file a PCT.
Got it. Thank you. For a peptide invention, what is the current PTO practice for an allowable range of homology in the claims?
That's very specific, and I am
Yeah.
not up on. I apologize that I am not up on what the PTO guidelines are in this area or the case law. So I would not want to venture a guess at this point. However, if there's two areas you want to look in, MPEP might have something on that. It lags a little bit from the case law, but whatever guidance the PTOs has, it will be in the MPEP, so you can take a look there. And then case law, again, case law is kind of whatever case has to go through the system. I'm sure there have been some cases along that line and have dealt with patents and tested the obviousness of them. So I think there could be some guidance there. I just don't know what it is right now.
Totally fair. Thanks, John. Okay, if you get approval for one or more new indications to a drug that is approaching patent expiry based on a previous or primary indication, what will be the impact on generics? Is that when the generic would try to carve out the new indication?
It's certainly a scenario where a generic might try to carve out the indication, because if there's an approved drug and that the approved the brand has an indication, and again, let's take this hypothetical, that indication's going to lose its patent coverage protection. then the brand would say, fine, I won't have an issue with that patent once it loses its patent protection. That indication is fine for me. If you have patent protection, and again, in this hypothetical, that a newer patent is coming on with a different indication, and then in my scenario, let's say that new indication is going to be written to the brand at that point. Then a strategy that a generic would almost definitely think of, don't know if it would work or not, but would think of is to carve it out, to carve out that one. And if you can carve out that one, then you would have a non-infringement position, because the case law is actually fairly strong. And if you don't have, if the patented indication is not in your label, you don't induce infringement. Again, facts can change and there's different scenarios can happen. However, that's a pretty strong position to have. So yes, that is definitely an area where a generic would think that. Beyond that, I mean, a whole bunch of other different scenarios could occur. And again, you always have to think about a carve out too. The FDA might not accept the carve out. So that might be an issue, and that approved indication then becomes there's not a non-infringement position anymore. You'd be in an invalidity position. So that could definitely happen. But yes, that's kind of a ripe area for a carve out.
Great. All right. A question from one of our Catalyze investigators. What is the best way to protect a repurposed drug? Maybe along the same lines as the last question.
Purpose drug. Well, again, let's take the hypothetical where the repurposed drug has no OB patent protection anymore. So that's gone. So, and again, I'm repurposed drug. Let's take a small molecule drug. So that would be Hatch-Waxman. So that would be the OB. So most brands would definitely want to be looking to OB protection. And at that point, the repurposed drug, let's take a hypothetical where it's a 505(b)(2). So you're basically tacking it on to the old brand, but you're coming up with a new one. And the 505(b)(2) can have an OB patent. So that's, for small molecule, that's kind of where a brand would be going in the direction, because again, the OB leverage is going to gum up the works, at least for 30 months if you have to P4 that OB patent. And it definitely will, the more OB patents you have, the more roadblocks you can make. Beyond that, and again, that's not BPCIA land. BPCIA land would be a different scenario. At the end of the day, though, having more patent protection where you can find a mechanism to assert them is at a minimum leverage. Beyond that, there probably could be other IP scenarios where you could think of, but they're not as readily apparent for drugs. Patents are typically the one you're trying to assert at that point.
Great. Okay, just a few more. One from Nitin. After filing a PCT, if one chose to only file the national utility before the due date, can they file in other countries in the future?
Yeah, I mean, PCT, and I haven't dealt with PCT filings in 25 years. So this is not, I definitely do not want to give any kind of definitive answer, but there are different stages in the PCT. There's a chapter 1 filing stage and a chapter 2 filing stage. I forget the timelines of these things, but to keep your options open in the PCT world, you want to hit those timelines. If you're outside of those timelines, then you'd have to come up with different creative ways to get something there, because the issue with missing those timelines is you don't have your priority date anymore. The things you've basically broken the chain at that point. And like I said, the international the different patent offices, they're very similar to the US, but there are differences. So there might be ways that you could revive something in the US, but it would not work internationally. So usually the advice pretty much most counsel would give is don't miss your dates, or if you miss your dates, you are consciously making the decision to not file.
Perfect. All right. I think we are slowing down in the Q&A as well as in the chat. If I didn't address your question, please let me know. But I will take this time to thank John so much for giving a great presentation, and also remind all of you that a recording will be available of this presentation later in the week. That'll be on our website, nhlbicatalyze.org /events. So please visit us online. And if any other questions come up, you can always email myself, meastman@rti.org, and I can get your questions over to John. I think we have addressed all of the questions. Lots of thanks to you, John, and thanks to everyone for joining today's webinar. Have a great day.
Thank you.